Uniform Act. As many of you know, receivership is a very useful but poorly understood remedy for securing property during a mortgage foreclosure, and ideally for also selling property at a better price than you would get at a foreclosure. Now, without exaggeration, the slide in front of you now shows the state of receivership law in the states today. Now, even though it is an ancient equitable remedy and the rules are, or should be, relatively similar in all the states, we have a real hodgepodge. They range from very comprehensive code-like statutes that go into microscopic detail in Minnesota and Washington to a number of states that have just a bare mention either in a statute or a court rule saying that whichever court has general equity jurisdiction can appoint a receiver. And in the middle, there's a mix of states that have either statutes or court rules that address some, but not all common issues that come up in a receivership, and don't always address those issues very clearly. Next slide. So this is where the Uniform Law Commission comes into the picture. For those of you who aren't familiar with the ULC, it's an organization of the states themselves, so it's not a special interest. It's actually a governmental organization. And we're the people who brought you the Uniform Commercial Code and a bunch of other uniform and model laws that states have been enacting since the late 1890s. Now, in this process for the Receivership Act, we followed a fairly standard approach that the conference follows. We first started with a study committee that looked at the current state of the law in all states. We examined what actually takes place in the states. So we looked at not only what's on the books, but actually how it's administered, how courts deal with issues, and how litigants deal with issues. We also reached out to a number of groups and practitioners so we could get some broad stakeholder participation. First and foremost, we brought in the American Land Title Association, or as I like to call them, the Supreme Court of Titles, because selling real estate obviously involves title insurance issues, and court sales always involve issues of marketability and insurability. The American Bar Association was also an active advisor here, and that's where Kay comes in as the Business Law Section's official advisor. A number of real estate bar organizations, commercial finance bar organizations, receivership organizations, and the judiciary as well. The American College of Business Court Judges and the National Center for State Courts were active participants in this process. Then we spent 2.5 years drafting in face-to-face meetings that usually took place over 2 full days at various locations around the country, where we brought together not only the members of the drafting committee, but the ABA advisors and these stakeholders. Then the Uniform Law Conference approved the act this year after the entire conference looked at the statute and made some changes and, frankly, some really good improvements to it. And it's now in the hands of state legislators, but it needs people like you who are going to be affected by this or who would be using it. If you need it and want it, you need to go to your state legislatures and push for enactment. Okay?
Thanks, Tom. The goals of the drafting committee were to provide a basic set of standard rules for receiverships. For example, appointment and powers of real estate receivers, the necessity and amount of the receiver's bond, and the eligibility requirements to serve as a receiver, while at the same time giving courts flexibility to design the most appropriate remedy under the circumstances. Next slide. The objectives were to bring clarity to the grounds for appointment of a receiver. The Act establishes standards under which a court may appoint a receiver in the exercise of its equitable discretion, and the Act also establishes standards under which a petitioning lien holder is entitled to the appointment of a receiver either as a matter of right or within the court's discretion. The Act also outlines the receiver's powers. There are receivers' presumptive powers, for example, to collect, control, manage, conserve, and protect receivership property, as well as those the receiver may exercise only with court authority, for example, to make improvements to the receivership property. Under the Act, the receiver has the authority to sell real estate outside the ordinary course of business, which will allow it to transfer free and clear of liens, except for senior lien holders, and rights of redemption, and the liens are then transferred to proceeds. It also protects the rights of third parties. The Act requires that notification is made by the receiver of his or her appointment, unless the court orders otherwise. There are provisions requiring creditors to file claims to receive a distribution. There's a requirement of a notice and opportunity for hearing for an action of the receiver outside the ordinary course of business. And if the court appoints the receiver ex parte, it may require the party seeking the appointment to post security for any damages, attorney's fees, and costs incurred by a person injured by the appointment. Next slide. Tom?
Thanks. Now, in the course of a receivership case, similar to what happens in bankruptcy court, the court will deal with a lot of routine matters as well as many significant matters, such as the appointment of the receiver in the first instance and the sale of receivership property. So one of the things we did in the Act was we put in a general provision that is kind of a one-size-fits-all that should work under all states' procedural rules to allow for a flexible process of notice and an opportunity for hearing, so that, for instance, in routine matters, if nobody objects, then the court could just act on the receiver's or some other moving party's request. Now, when you do look at the statute, it's similar, but we think much better than what's in the bankruptcy code. And we follow kind of a common sense approach, but we're very mindful of constitutional issues because, again, we're in the state court system, and the states do have fewer powers than the bankruptcy courts do under the federal system. Next slide. Next slide, please. So the scope of the Act, it covers commercial real estate and operations on that property. Generally, property is going to be within the scope of the Act unless it has 1 to 4 dwelling units on it. However, to avoid gamesmanship and to deal with situations where there might be 1 to 4 residential units on a property and it still has a commercial character, there are a number of 1 to 4 unit properties that get brought back into the Act. So in essence, they're carve-outs from the carve-out. For example, if the property is used for business purposes other than an incidental use as a primary residence, then it's subject to the Act. So, for instance, a farm or a ranch where the owner lives on the property, or employees live on the property seasonally or year-round, technically that is residential property, but it's mainly a commercial enterprise, so it would be subject to the Act. This also prevents things like the story from a number of years ago in Texas where somebody moved into the top floor of an office building to claim it as a homestead. So again, that would not take you outside the Act. Second, if the property is collateral for a debt incurred when the property was used for business purposes, it's going to be subject to the Act. Third, if the owner planned or is planning to develop the property to be sold or leased in the ordinary course of business, then it is also subject to the Act. This gets at, say, a situation where the developer is going to put in more than 4 dwelling units, but fewer than that actually get put in place before there's a default under the mortgage. Then again, this is commercial property. And the main final carve-out from the carve-out is that if the property owner collects or has a right to collect rents from somebody who's other than an affiliate, then even 1 to 4 family properties would be subject to the Act. So for example, if, as many of us are experiencing now, you have kids who have either failed to launch or they've come back for a while and they might be renting a room in your house, as a family member, that's really not converting your home into a commercial property. So you would be outside the scope of the Act. Or if somebody just has a home office or does a significant amount of work, as many of us take home every night, then that wouldn't convert your home into a commercial property. Okay?
Next slide, please. Under the Act, the grounds for appointment are in a prejudgment situation, if the property is subject to waste, loss, dissipation, or impairment, or if the property has been or is about to be the subject of avoidable transaction. Post-judgment, it's to carry the judgment in effect or to preserve non-exempt real property. There's also in the Act a catch-all provision which allows the appointment of a receiver on equitable grounds or for equity. Another basis for the appointment is during the redemption period to secure rents or to protect property, or in connection with a mortgage foreclosure or the enforcement of a mortgage to protect the property, again, that is subject to waste, loss, dissipation, or impairment, as with the prejudgment. The mortgagor agreed to the appointment upon default, which you may find in the mortgage documents or loan documents. The mortgaged property or other collateral is not sufficient to satisfy the secured obligations. The owner fails to turn over the mortgage proceeds or rents, or the junior lien holder has obtained the appointment of a receiver, and this is to protect senior lien holders. So in the event that a junior gets a receiver, one of the grounds would be to allow the senior to also get the appointment of a receiver. Next slide, please. The receiver's qualifications in the Act are written in the negative, but they're fairly common sense. It requires the prospective receiver to provide sworn evidence of his or her independence. The Act also lists the circumstances that would disqualify a person from acting as a receiver, but it clarifies that a person is not disqualified merely because the person served as a receiver in or was owed compensation in a prior unrelated dispute, or because the receiver is obligated to a creditor of the owner on a consumer loan that is not in default, or because the receiver maintains a deposit account with such creditor. The Act allows a party seeking the receiver to nominate or to suggest to the court the potential receiver, the qualifications of the receiver, but it makes clear that the identity of the receiver the identity of the receiver and the appointment is within the discretion of the court, and this is consistent with common law. Next slide, please, Tom.
Actually, Tom, before you start, this is Brian Dolan again. For folks that are interested in CLE, I wanted to give the first code words. There are going to be 4 code words you need to write down that I'll give you as we go through here. The first one is going to be ACT. That's A-C-T, ACT. And then I'll come in about 15 minutes with the second one for you to write down. Thanks, Tom.
Thanks. Now, the Receivership Act contains a number of receivership concepts that the Bankruptcy Code and the predecessor Bankruptcy Act of 1898 took over and really in some cases stood on their head. Now, one of those is the lien creditor status of the receiver. Under Article 9 of the UCC, the term lien creditor includes equity receivers, and because this is a receivership statute, we wanted to make sure that that rule would apply no matter what. So we specifically granted the receiver lien creditor status. Now, it's the same lien creditor status as under Article 9. So in effect, what would happen is if a secured party on personal property didn't perfect its interest, its claim would be junior to the receiver's fees and expenses and to other costs of administration. And it would also be junior to any other perfected secured interests, but it would be senior to general unsecured creditors. And there's a difference between this act and bankruptcy, where in a bankruptcy, the unperfected secured party is totally unsecured and is on the same level as the general unsecured creditors. Now, on real estate, it depends on what state the property is in. In most states, a lien creditor, such as an attaching creditor or creditor who levies an execution on property after judgment, is not considered a bona fide purchaser, so it would be subject even to an unrecorded mortgage. There are a few states, they tend to be in the older parts of the country, mainly in New England in my experience, where attaching creditors do have the same rights as a bona fide purchaser under the Recording Act. And so those states, you would just follow that same rule, and it would be just like under the UCC. So if there's a first mortgage that was never recorded, a second mortgage that was recorded, then the priorities would be second mortgage, receivership fees and expenses and costs of administration, then the first mortgage holder, then any general unsecured creditors. There's also no Moore versus Bay rule here, where the lien creditor status is not a superpower. It essentially just rearranges the priorities slightly. Next slide. The similar concept is after acquired property. In a bankruptcy case, a lot of revenue generated from real property is not actually going to be part of the secured lender's collateral. For instance, accounts receivable, hotel charges, resort charges, greens fees, and parking fees. Those generally get cut off by the filing of a bankruptcy, but they don't get cut off by the appointment of a receiver. So this is a significant difference for creditors of hotels and other developments like that, where the income is not, strictly speaking, rents under a written lease. Okay?
Next slide, please. In the Act, there is an affirmative duty, and it requires the owner of the property to assist and cooperate with the receiver, to preserve and turn over all receivership property in the owner's possession, custody, or control, and to identify all records and other information relating to the receivership property, including passwords and authorizations. The receivership is made up of receivership property, which is defined in the Act as the property of an owner described in the order appointing the receiver, and it specifically includes proceeds, products, offspring, rents, and profits of or from the property. Third parties, upon demand of the receiver, are also required to pay to the receiver a matured debt unless the debt is subject to a set-off or recoupment, and turn over receivership property to the receiver unless the creditor holds a possessory lien, so they're holding the collateral in their possession to perfect their lien. Then the creditor is entitled to retain possession of the property until the court orders adequate protection of the creditor's lien. The Act also has a provision that noncompliance of turnover upon demand may result in either in civil contempt. And of course, this is unless there's a bona fide dispute as to the receiver's right to possession, custody, or control of the property. Next slide, Tom.
Thanks. As Kay had mentioned earlier, there are a number of different powers and responsibilities that receivers have, and the Act divides these into what we'll call routine powers and duties that are automatic unless the court orders otherwise. And then there are non-routine powers and duties where specific court approval is necessary before the receiver can take certain actions, the most notable one being the sale of the real property. Another important one would be the rejection or adoption of an executory contract or an unexpired lease of the property. Okay.
Next slide. Like the bankruptcy code, this Act does have an automatic stay and an injunction. An order appointing the receiver acts as a stay to protect receivership property by prohibiting the exercise or control over or the enforcement of a judgment against receivership property. The Act also authorizes the issuance by the court of an injunction if it's necessary to protect receivership property or to facilitate the administration of a receivership, of the receivership. The stay, however, does not apply to an act, action, or proceeding to foreclose or otherwise enforce a mortgage by the party seeking appointment of the receiver, or an act, action, or proceeding to perfect or maintain or continue perfection in the receivership property, does not act as a stay for the commencement or continuation of criminal proceedings or the commencement, continuation, of enforcement of a governmental unit of its police powers or regulatory powers other than for a money judgment, or the establishment of a governmental unit of a tax liability against the owner or the receivership property. A person stayed for cause can petition the court for relief from the stay or the injunction if one has been issued by the court. There's also a provision that says for knowing violation of the stay or injunction, the court may award actual damages caused and attorney's fees and expenses and sanction the violation as a civil contempt. Next slide, please. As I mentioned, go ahead, Tom.
Oh, sorry. We just wanted to get into what in many ways is the heart of the Act, the receiver's power to sell real estate. One of the biggest uncertainties in our crazy quilt estate receivership law and practice is the receiver's power to sell property. Now, a receiver's sale generally will generate a better recovery for everybody concerned than a foreclosure sale, because a foreclosure is, by definition, a forced sale. And as a general rule, what a receiver will do is market the property, will allow people to conduct some due diligence. The receiver can provide some basic information about the property, and people can make a more informed decision and hopefully a higher price, so that the net recovery to the mortgage holders and to the owners of the property and other creditors will be better. So this really is one of the key features of the Act. Next slide. But a sale must be approved by the court. That's a key element of the sale power here. It's a strictly non-routine power if it's outside the ordinary course of business, and that's what most receivership sales are going to be. But the way we've crafted the sale provisions of this Act, the receiver can transfer marketable and insurable title. Now, when the court is looking at a prospective sale, it's going to take into account the views of everybody who's got a stake in the outcome on that sale. And it also allows the court to approve some flexible marketing efforts, the buyer due diligence, as I had mentioned, and some flexible sale terms that are intended to generate a better recovery. So it doesn't have to be, strictly speaking, an auction. It could be listed with a broker. There could be competitive negotiation among competing buyers. There are any number of things that a court can do depending on the nature of the property to maximize the value. Now, one of the key elements to a sale is that it be free and clear of liens. We specifically authorize that in this Act with a couple of exceptions. Now, the liens that are taken off the property as part of the sale will attach to the proceeds. And one of the uncertainties we've clarified in the Act is that those liens will attach to the proceeds even if those liens are underwater. So there's no question but that any lien free of which the property is sold really is no longer on the property itself. Now, there are some significant protections the Act builds in for senior lenders on a sale free and clear of liens. For example, if a junior creditor has obtained the appointment of a receiver, the property can't be sold free of the first mortgage unless the first mortgage holder consents. So, in the case of a lender in a REMIC transaction who has bargained only for full payment according to the terms of the note and either does not want or cannot really accept a prepayment, as long as those restrictions are otherwise legally valid, the property can't be sold free of that mortgage unless, again, the lender consents. Now, in a situation where the lender bargained for full payment, but in lieu of requiring this perfect tender over the term of the mortgage, bargained for a prepayment penalty if the loan was accelerated or prepaid for any reason, then that loan would have to get paid off as part of a sale, unless, of course, the senior lender consents to it. So, in effect, the senior mortgage holder has a de facto veto power over many different types of sales. And in a situation where the senior lender is the petitioning creditor and obtained appointment of the receiver, because receivership is a remedy, the receiver can limit what remedy it wants the court to grant. So if it doesn't want the property sold, it just wants the property protected, for instance, rents collected, etc., and it wants to go through its foreclosure sale, it can ask the court for only that much relief, and presumably that's what the court would do. And in all cases, secured creditors are allowed to credit bid. Next slide, please. Now, as many of you know, in the bankruptcy code, there is a safe harbor provision that protects a good faith sale if somebody appeals the order approving the sale. But in practice, that protection really has been fairly limited, and in many cases, when an objecting party does appeal a sale order, that's enough to stop the music, and the sale won't go through until it gets resolved. Within the powers that the states have, we have tried to bolster the safe harbor. For instance, the safe harbor protections here apply not only to appeals, but to any effort to revisit the sale order, such as a motion to reconsider, which is another technique that disgruntled parties sometimes try to use to hold up a receiver's sale. It also fixes a potential problem that the bankruptcy code has in jurisdictions that follow the Clear Channel case, where the court found that it couldn't undo a sale on appeal, but it could restore the liens free of which the property had been sold. So in effect, the buyer got the privilege of paying twice to buy the property. We didn't think that was an appropriate result, so the Act specifically says that if a good faith buyer takes it free and clear of liens, those liens cannot be restored as part of the relief that a court may grant in overturning the sale. Okay?
There's no specific standards in the Act for a receiver to borrow money outside the ordinary course of business unless there's approval by the court after notice and opportunity for hearing. So you have the due process protections there. Under existing common law and case law, priming liens are the authority for a receiver to borrow money and grant the lender of those funds priority over pre-existing liens is prohibited without consent of the pre-existing lien holders. Nothing in this Act changes the existing precedent. Next slide. Again, like the Bankruptcy Code, there are provisions relating to executory contracts in the Act. Executory contracts, by definition, includes unexpired leases. Under existing receivership law, a receiver does not automatically become bound to the owner's existing executory contracts. The Act allows the receiver to evaluate the executory contracts and determine whether they are burdensome or beneficial, and then act accordingly by adopting them or rejecting them. If the receiver adopts the executory contract, the Act allows the court to condition adoption on assurance of the receiver's ability to perform. If the receiver rejects the executory contract, the rejection constitutes a breach, and the counterparty is allowed to file a claim against the receivership. These rules on adoption and rejection would include leases if the tenant is in receivership. If the receiver doesn't adopt or reject within a reasonable period of time, and that term is undefined under the Act, then the executory contract is deemed rejected. In contrast to the tenant, there are particular provisions in the Act dealing with real property leases where the landlord is in receivership. For the most part, the Act protects tenants from having their leases rejected by a receiver. The receiver cannot reject a lease of a tenant that occupies property as a primary residence, cannot reject the lease if the receiver is appointed at the request of an involuntary lien holder, such as a judgment creditor. If the receiver can't reject if the receiver appointed at the request of a mortgagee, and the lease is senior in priority to the mortgage, the tenant has a non-disturbance agreement with the mortgagee, the mortgagee has consented, either directly or indirectly, by timely objecting that the lease violates the mortgage, or the lease was commercially reasonable at the time it was negotiated, and the tenant did not know or did not have a reason to know the lease violated the terms of the mortgage. This last provision protects leaseholders who entered into leases in good faith and does not allow a receiver to just come in and reject because maybe the market has turned and it would be in the best interest to reject the lease. Next slide, please, Tom.
And actually, sorry, Tom, this is Brian Dolan again. I wanted to give the code word for those looking for CLE. So the first word, again, was act, and the second word is going to be uniform. So it's act and uniform. Thanks, Tom. I'll change the slide now.
All right, another issue that comes up in some receivership cases is what type of personal protections a receiver has for what he or she has done or has not done in a case. Now, as part of our study process, we looked at this issue in great detail, and this is one area where we actually found that the common law really can't be improved on, because what we concluded after this extensive study were two things. Is number one, the courts generally know how to handle these very fact-intensive questions. And second, the best articulation we could make of the rule that courts generally follow is really just, unless the receiver acted like a jerk, the receiver isn't generally going to be personally liable for acts or omissions in the course of administering the case. So this is a little different than what would happen in a federal receivership or in a federal bankruptcy case. But on balance, we decided to defer to whatever the state's common law was on the issue of receiver's immunity. But we did specifically install the Barton Doctrine. There's a 19th century U.S. Supreme Court case called Barton where the court held that if someone wants to sue a receiver personally rather than just in their representative capacity and wants a personal judgment against the receiver, they have to go to the appointing court and get permission to sue. And if that permission isn't granted, then technically no court will have jurisdiction to hear a case against the receiver. That rule has been applied in a number of states, but in many states it just hasn't come up, so there are no reported decisions on it. But we felt that the Barton Doctrine was good law, so we kept that in and codified it. Next slide, please. Now, the Act requires some meaningful and productive notice to creditors and to other parties who are going to be affected by the receivership. But the Act also allows the claims process to be tailored to suit the creditor body and the receivership property that is in the case. So, for example, if the real property is underwater and the secured creditors are not going to get paid in full, the court can either dispense with or can limit the notice to general unsecured creditors. Creditors who are required to file proofs of claim would submit them actually to the receiver rather than filing them in the court docket. And the receiver has a duty to review those claims and report to the court on which claims he or she thinks should be allowed or disallowed and at what either level of security or priority and in what amount. It's a routine duty to provide this, but the allowance and disallowance of claims is strictly within the court's purview, so all the receiver could do is make recommendations on this. Once claims are allowed, then the assets of the receivership, generally cash, will be distributed to the creditors according to law that's outside the Receivership Act. So in essence, secured creditors will get paid first. Priority unsecured creditors, which often includes tax claims or wage claims, would probably come next, and then general unsecured creditors. And if there's a surplus, then the owners of the property would receive what is left. And at each level, it would be pro rata. Okay.
Thank you. Next slide, please. There may be a circumstance under which some or all the receivership property is located in a state other than the state in which the receiver was appointed. To exercise control over such property, it will most likely be necessary to have an ancillary receiver appointed in the state where the property is located. The Act provides that the receiver appointed in another state or his nominee or her nominee may be appointed in the state where the property is located if the receiver or nominee is eligible for appointment under the Act, so has to meet the eligibility requirements, and the appointment furthers the foreign receivership. Then the ancillary receiver would have all the powers, rights, and duties of the receiver appointed under the Act unless the court orders otherwise. Next slide, please. Now a topic that's near and dear to all of our hearts, which is how the administrative fees and expenses get paid. The administrative fees and expenses of the receiver, which would include those of any professionals retained by the receiver under the provisions of the Act, must be approved of the court and must be reasonable and necessary. Generally, these fees are paid from the receivership estate, from the cash flow of the receivership. However, if there's insufficient funds in the receivership to pay the allowed fees and expenses, the court may order that the person who requested the appointment pay such fees and expenses. In certain circumstances, the court may alternatively order that the person whose conduct justified or would have justified the appointment due to the waste, dissipation, etc., be required to pay the fees and expenses. Next slide, please, Tom.
All right. I would just urge you again to contact your legislators, your trade groups, and bar associations, and spread the word about this act and the good things that it does, and seek enactment of it. The Uniform Law Commission and the enactment committee for this act are ready at any time to help you in any way we can. The main contacts would be myself and Ben Orzeski, who's the chief counsel at the Uniform Law Commission, and all of our contact information is up here. I see we've ended a little early, so we have plenty of time for questions and further discussion on anything that people would like to cover.
I do see that there is one question, which is the remedy available for situations, the receivership available for situations where partners in a closely held partnership are at an impasse and as a result distributions are being held hostage? I can respond to that first one, Tom, if you want to join in. I believe that would could fall within the waste dissipation prejudgment justification or grounds, and also clearly within the catch-all where the appointment of the receiver would be for equitable purposes.
No, I agree with that. And in a number of states, there are also specific statutes in either the Business Corporation Act or the LLC Act that allow for the appointment of a receiver when there's oppressive type of conduct. And as states look at the Receivership Act, they may want to integrate those provisions with the Act so that they dovetail nice and smooth, but the Act in and of itself would allow for this to take place.
I would like to give another code word, if you don't mind, Tom and Kay. The third code word for those looking for CLE is going to be contract. That's contract. So the first word was act, second is uniform, and the third is contract. And we do have another question. Sorry, it just popped off my screen. I'll just throw it out to both of you. Can you address the constitutionality of rejecting contracts?
Tom, you want to start with that?
Sure. Basically, what a rejection of a contract is the breach of the contract. It's not the elimination of the contract as if it never existed, because obviously states are subject to the clause in the U.S. Constitution that prevents the impairment of the obligation of contract. So all the rejection actually does is it constitutes a breach, and it allows the counterparty to the contract to file a claim for whatever its damages would be under state law for breach of that contract.
So I do have the Q&A button up here highlighted, so if anyone does have another question, now would be a time if you wanted to hit that. And then otherwise, I'll give the final CLE word, and we can end a little early today. All right, I'm not seeing any other questions. Feel free to send it in now if you want. Otherwise, the final CLE word is going to be pepper. That's P-E-P-P-E-R. If you are interested in CLE, my email address is on the screen. It's dolanb@pepperlaw.com. Feel free to send me an email asking for the CLE form, which I'll send you, and we can turn that around for you rather quickly. The other two pieces of information, one is we're recording the webinar today, so it's going to be on our websites. But we're also going to have a link to the Act itself, if you're interested in that, off the website. Kay or Tom, any final comments before we stop today?
This is Tom. One thing that I would mention is if you want more deep background on the Act, besides the final version and the official comments, you can go to www.uniformlaws.org. Look for the Act where it says Find an Act, and all of the material that was circulated as part of the drafting process, including a detailed 50-state survey of the law on receivership, is available for download as different PDF files.
And we did get one quick question, if you don't mind. Do you need court authority to enforce payment of post-receivership claim/obligation?
Okay.
I think the answer to that is whether it's in the ordinary course of business or whether it's outside the ordinary course of business. If it's ordinary course of business, the receiver will have the authority under the order and under the Act to pay ordinary course. If it's outside the ordinary course or a pre-receivership type claim, then court authority would be necessary. Tom, do you have anything to add to that?
No, that's the way I see it too.
Hey, everyone's time today. Thank you so much, and we're going to end right now at 12:45 Eastern. Thanks a lot.
Thank you.
Thanks very much.